my name is Anya Prince, and I'm an associate professor at the University of Iowa College of Law. And I'm going to talk today about some of your legal rights surrounding hereditary cancer, particularly around insurance. As a note, I have no conflicts of interest to disclose. So when somebody has a genetic predisposition to cancer or has a genetic predisposition in the family, there can be a lot of questions swirling around beyond just the medical questions, such as how do I access care? How do I plan for the future? What sort of privacy do I have? Am I at risk of genetic discrimination? What are some of the familial implications? So I'm going to talk today about some of those non-medical issues, particularly around access to care and discrimination. So in today's presentation, I'm going to talk a bit about one law called the Genetic Information Non-Discrimination Act, or shortened to GINA. And we'll talk about what some of the gaps are in that law, what the coverage is of that law, and then we'll talk about how some of the other state and federal laws might fill in some of these gaps in GINA. And then towards the end of the presentation, I'll shift and talk really briefly about another law called the Care Act, and talk to you about how that has to do with access to information in your medical information. So let's begin with GINA. So GINA was signed into law in 2008 by President Bush. So it's been enacted and in force for over a decade now. And what GINA does is there's really two main parts of the law. First, it has a section on anti-discrimination, or it covers anti-discrimination. So what this does is GINA stops certain entities, and I'll talk about those, from using genetic information to make adverse decisions, right? To make a decision that's bad for a person simply because of their genetic information. So let's talk about some specifics. So GINA covers two different entities, right? One is around employment. They cover employers. And in employment, an employer cannot fail to hire, right? They can't fire, they can't change terms of compensation or conditions of employment, and they can't say we're going to treat this class of employees differently than another class simply because of somebody's genetic information. The other big category that GINA covers is health insurers. So health insurers are not allowed to charge higher premiums or change how much you have to pay into your healthcare plan. They can't deny coverage or deny insurance because of genetic information. Also, genetic information cannot be considered what's called a pre-existing condition. So let's talk about what I mean by genetic information. So GINA defines genetic information to include genetic test results. So if you go out and get a BRCA test to see whether or not you have a predisposition to breast or ovarian cancer, for example, that result of that genetic test would be considered genetic information under the law. And that's pretty self-explanatory, but GINA covers actually a lot of other things that are considered genetic information. So it actually includes family medical history. So if you have a family medical history of cancer in your family, or a family medical history of high blood pressure, that in and of itself, without necessarily taking a genetic test, is counted as genetic information. Also, if you participate in genetic research, that counts as protected information. And finally, if you use genetic services, such as go to see a genetic counselor or participate in some genetic education, that as well counts as your protected genetic information. One note, and I'll come back around to this later, is that it doesn't include any manifested conditions. So what I mean by that is that BRCA test that you took might be protected, but if cancer actually developed, then that cancer itself would not be protected by GINA, although it might be protected by some other laws that I'll talk about a bit later. So those are the anti-discrimination protections of GINA. But GINA actually has a lot of privacy provisions as well. So by this, I mean that GINA stops health insurers and employers from collecting genetic information in the first place, with some exceptions. So the rules of this is that your employers, or a covered employer or health insurer, cannot what's the language of the law is request, require, or purchase genetic information. So they can't say to you, hey, I want to know your genetic test result, right? And remember, this includes that broad definition of genetic information, including family history. Now, there are some exceptions, as I mentioned, so I won't go through these all in great detail. But some include things like if they accidentally overhear you talking to a coworker and they learn this information, if you have to fill out a family or medical leave certificate, and some other exceptions for collection that are more rare, things like wellness programs or some genetic monitoring. There are also exceptions in insurance where insurers are allowed to collect genetic information if they're making a decision to pay for a service. So for example, if you wanted to get a prophylactic mastectomy, the insurer could say, well, we would like to see proof that that's medically necessary, and that proof may be a positive BRCA test, right? Now, in this case, they're only allowed to ask for the minimum amount of information necessary, so they couldn't say, or they're not supposed to say, well, we would want your whole entire family history of heart disease and all of that in order to pay for that prophylactic mastectomy. They also might have incidental collection, like that overhearing thing where they request your medical records from the doctor and then they accidentally see some genetic information. Now, keep in mind that even if employers or health insurers get access to genetic information, they still can't use it to discriminate, right? So they have to keep that information confidential, and they can't, charge higher rates or fire somebody because of that information. Of course, that's a little bit harder to prove at times. And so really those privacy protections that allow you to limit the amount of genetic information that even comes to the employer or to the health insurer are really strong protections and really helpful for individuals. And so in some ways, the privacy provisions are not often talked about when people talk about GINA, but they actually are the ones that the EEOC is litigating the most. And the EEOC is the Equal Employment Opportunity Commission. This is the governmental entity that oversees employment discrimination laws. And so the EEOC, especially quite recently after GINA was passed, so in the early 10s, 11, 12, 13s, they brought some lawsuits against employers that were collecting genetic information. And usually that meant they were collecting family medical history as part of wellness programs. So those are some of the cases that have been brought in this area. Okay, so GINA is really great because it provides those privacy protections and those anti-discrimination protections, but there are some gaps in GINA. So one thing is that GINA only applies to certain health insurers and certain employers. So let's talk about employers first. GINA applies to state and local governments, and it applies to private employers with 15 or more employees. It also covers some federal employees, but it doesn't apply to Indian tribes or bona fide private clubs. In terms of federal or military employees, there is an executive order as well that was passed before GINA that prohibits genetic discrimination in hiring and promotion decisions in the federal government. And as I said, GINA has also been read to apply to some federal government employees. If you're in the military, you can also look to the military anti-discrimination policies because different branches of the military might have different anti-discrimination policies surrounding genetic information. But use of genetic information may occur in military employment, and sometimes that's to protect individuals. So there's an example of the military looking at how people process malaria medications, and there's a genetic marker for that. And so they might not deploy them in certain settings if malaria medications are needed. Okay, as I said, GINA only applies to private employers with 15 or more employees, so really those medium to large businesses. But it doesn't cover these really small businesses with 14 or fewer. So here's where you have to look to state employment discrimination laws, because state employment discrimination laws often apply to smaller businesses. And indeed, 35 states have some form of employment laws related to genetic information, and some of those apply to companies that have even as few as 1 or 2 employees. So you might have some protection from the state level. One thing to keep in mind is that the provisions are generally less robust than in GINA. And what I mean by that is those privacy protections that I was talking about, those might not exist at the state level. However, penalties might be higher. So if an employer does discriminate, you might be able to have higher penalties imposed if you brought a lawsuit and won that lawsuit. So that's in some of the gaps in the employment section. Let's talk about some of the gaps in the health insurance section. So GINA applies pretty broadly to most health plans that we can think of. It applies to group and individual plans. So these are ones you might get through your employer or ones you might buy on a health insurance exchange through the Affordable Care Act or Obamacare's health plans. It applies to Medigap plans, which are plans that are linked to Medicare. Now, it doesn't apply to TRICARE or Veterans Health. TRICARE is a military health insurance plan, or some other federal employee health benefits plans. It's important to keep in mind, I'll talk a little bit about these in a second. The other big gap is that GINA only applies to health insurance. It doesn't apply to any other insurances such as life insurance or long-term care or disability insurance. So let's talk a little bit about some of those gaps. So in the federal and military health programs, in group health plans like this, there are also protections against genetic discrimination or charging different people in the group different insurance premiums. And so you might still be protected in one of these health plans. So as I said, they do not take into account genetic information setting rates at the individual level because you're part of this group plan. What about for life, long-term care, and disability insurance? So these are regulated at the state level. And generally, any state law that talks about the use of genetic information by any of these 3 insurers regulates how the insurers can use this information and doesn't ban that use. And keep in mind that the definitions matter. So I talked about the definition of genetic information in GINA, that it's really broad and it includes family medical history. But at the state level, the definition of genetic information is usually not that broad. And so if there's a state law that protects in the life insurance realm, for example, it probably only protects or it only covers genetic test results or some other more narrow definition, as opposed to that broad family medical history and use of genetic services. If you're interested in state laws in this area, I have a recently published piece, and this is free to download from this website, that I did with a couple of co-authors, Jared Anderson and Anna Lewis, and we went through and looked at all 50 states and how they regulated use of genetic information by life, long-term care, and disability insurers. And this is our overall findings, but you can see our discussion of each of these individual state laws there. But it's really varied, right? So as I said, it's mostly regulating. And so if we look at this first column or the second column, that ban on use, only 1 state completely bars life insurers from using genetic information. And then we can see 2 for long-term care and 3 for disability insurance. That little asterisk is that one of the laws about disability insurance only applies to group disability plans. The one life insurance bar was actually Florida. So in this past year in 2020, the Florida state legislature passed a law that now prohibits life, long-term care, and disability insurers from using genetic information. So Florida in 2020 became the first state to ban life insurers from using genetic information. So we'll definitely be tracking this bill or this statute as it goes forward to see what the impacts of that are. Some of the other common requirements is if they require you to take a genetic test, they must get informed consent, or they have to have actuarial justification to use genetic information. What this means is they have to be able to show that whatever genetic information they're using is linked to the increased risk or increased cost to the insurer. And so this can come into play, if there's sort of questions of what the genetic information risk is, they might not be able to use it, although these laws aren't robustly litigated or anything like that. Okay, so let's turn and talk, that was a little bit about the gaps in coverage. One other thing to keep in mind that I mentioned is that GINA only protects the genetic information and it doesn't protect manifested conditions. So once symptoms develop, an individual has to look to other laws beyond GINA for protection. But we do have some laws that can be helpful here. So one is the Affordable Care Act, the ACA, or sometimes it's known as Obamacare. So under GINA, genetic information can't be considered a pre-existing condition. And under the ACA, health insurers cannot deny insurance based on any pre-existing condition, including having cancer, having high blood pressure, anything like that. And so really the Genetic Information Non-Discrimination Act, or GINA, and the ACA meet, right, where you really have a continuity of protection across the whole spectrum, that as symptoms develop, they're protected by the ACA, but that genetic information is also protected by GINA. In the employment context, it's a little bit different. So the Americans with Disabilities Act, or the ADA, is a law that protects against discrimination based on a disability. So under GINA, genetic information cannot be used to discriminate in employment, and under the ADA, employers cannot discriminate against individuals with a disability, but a disability is defined as having a substantial limitation. And so there is this gap or potential gap, it's a little bit of a gray area of what happens in the middle, where there's some slight symptoms that are developing. It doesn't rise to the level of disability, but an employer might take that into consideration. There is a potential way that this could be protected using a definition called regarded as. I'm not going to go into too much detail here. There's some literature on this gap if you're interested, but just noting that this is an area where there is some gray area of how this is protected. Okay. And then one other type of gap that we could talk about is a gap for payment of services. So while GINA stops health insurers from taking into account genetic information, it doesn't actually require insurers to pay for genetic testing or other recommended medical interventions. And here's where the ACA and some other laws can come into play. So let's turn and talk a little bit about insurance coverage for genetic related procedures. Okay, so generally insurance coverage for genetic testing and recommended medical interventions varies pretty widely across different insurances, across different health insurance, right? It also can be dependent on whether a person is asymptomatic or already diagnosed. But one thing that the Affordable Care Act did was it said that there is a group of benefits, preventive services, that have to be covered free of cost. So these are things like screenings, like a diabetes screening, or flu shots, some like colonoscopies and mammographies, things like that have to be covered. And there's a list of them, and on healthcare.gov you can see that list. But I'll talk about some that are really specific to the hereditary cancer community. So under the Affordable Care Act, BRCA testing is included as one of these preventive services. So under the ACA, health insurers have to cover BRCA testing free of cost to some enrollees. And I actually, coverage is for women, right? So the enrollees that have to be covered are women at high risk for BRCA. So for example, if you have a family history or or are of Ashkenazi Jewish descent. So there is this gap here, right, where it doesn't necessarily mean that there has to be free coverage for a male who has a family history, or if there's not really a family history, maybe you're adopted and want to know what your risk level is, right? It doesn't necessarily cover free of cost for everybody, but it does include genetic counseling for BRCA, as well as the cost of testing for those high-risk women. Another item that I mentioned that is considered a preventive service is mammographies. And so under the ACA, preventive mammographies must be covered free of cost. And when I say free of cost here, I mean no copay can apply, and it doesn't go towards your deductible, right? So the insurance company just has to cover it completely. You don't have to pay for any of it. One thing to note about the mammographies is that it only applies to women over 40, and it does not cover diagnostic mammograms. And so if it's maybe a remission from cancer and you're going back for a a check, right? That might be considered or might be coded as a diagnostic mammogram rather than a preventive mammogram. And then this insurance provision wouldn't necessarily kick in. And because it applies only to women over 40, we do have this gap where if you have a high family history, your medical provider might recommend mammography starting at 30 or in your 20s. And so the ACA doesn't necessarily cover this. And so if you're at younger age or know somebody who's at younger age who needs insurance coverage from mammograms, some state laws have mandates that mandate coverage for high-risk women, and there's also insurance appeals. I'll talk about appeals some more in a second, but I just want to cover one last insurance coverage section, which is preventive surgeries. So unlike the mammograms or BRCA testing, there's no mandates to cover preventive surgery, like a prophylactic mastectomy or oophorectomy. And so insurance coverage can really vary across plans. And sometimes this is dependent on whether it's a completely asymptomatic person who's looking for this surgery, or whether it's somebody who's like developed breast cancer in one breast and wants to have preventive surgery in the other breast. One thing to keep in mind is there is a law called the Women's Health and Cancer Rights Act, or WCRA. And here this says that if an insurance company covers a mastectomy, it must cover the reconstruction cost under the same rules and reimbursement levels. And that's just in general. And so if it covers the mastectomy at 80%, right, where you have to pay a 20% copay, it has to cover the reconstruction at 80% as well. So as I mentioned, let me talk a little bit about insurance appeals, because these are so important for all those gaps of where coverage might be needed, but there's not necessarily a mandate for coverage. So at times it may be necessary and a good idea to try to appeal insurance company decisions. And generally there are two broad levels of appeals. There's internal appeals and external appeals. And the Affordable Care Act really broadened appeal rights for many individuals, and it makes it easier to bring an appeal against an insurance company. And so there are a lot of different resources to help you go through those appeal steps. An organization that I actually used to work for, called the Cancer Legal Resource Center, has some step-by-step guides to insurance appeals. You can also look to your state Department of Insurance, as well as a couple other resources that I have here. And Force itself has some sample insurance appeal letters, so you can take the template that they've created and give that to your provider and help them fill in the template so that you could give that to your insurance company to appeal coverage as well. Okay, and as I mentioned, I now will talk a little bit about the Cures Act. And so the Cures Act was a law that was passed recently, and this is now switching gears to talk more about access to medical information in your medical records, as opposed to the other items that I was talking about, which is the discrimination protections and insurance coverage protections. So one thing that the Cures Act did, it did a lot of different things, but the one I'll talk about is access to medical records. So the Cures Act expanded a patient's rights to access their medical records. And one part of that, which actually started in full force this year in April, says that patients must be given immediate access to certain types of medical records. So these include things like lab reports or your procedure notes or some consultation notes. And if you are having problems accessing this information, there's a way to report what's called information blocking to HHS. HHS is the US Department of Health and Human Services, and that's the organization that oversees, it's the executive branch organization that oversees a lot of healthcare, including Medicare and Medicaid services. And so you can report this information blocking. Now, I said that this started officially in April 2021, but I think a lot of different medical centers have already started implementing this. So for example, if I go to the doctor, I might get a notification in the My Chart that my healthcare organization uses that says you have a new lab report. And so if you're starting to see more of those more recently, that's in part because of this law, this Cures Act, that says that patients have to get access to that information, and so that you see the lab reports and the notes that your doctors are getting access to as well. So in today's presentation, just as a reminder, we covered what the Genetic Information Non-Discrimination Act is, or GINA. We talked about those really important anti-discrimination provisions, as well as the privacy provisions of GINA. We talked about how GINA covers health insurers and employers, but it doesn't cover small businesses, and it doesn't cover insurances beyond health insurance. And that's where other state laws fill in the gap. So there may be state laws that say that a life insurer can't use genetic information in the case of Florida, or that says that a disability insurer has to get permission to use your genetic information in other states. We also talked about how the Affordable Care Act and the Americans with Disabilities Act help fill in some of the gaps for people with manifested conditions in terms of anti-discrimination protections. And then I briefly talked about the Cures Act and how that's really expanding our access to medical information in our medical records. And so thank you so much for tuning in to this presentation, and I hope you enjoy the rest of your conference.